Okay, welcome to another fun CLE. Today we're going to be discussing agency and partnership. This is a facet of contract law contract law, yes, but corporations law, where we have not formed a corporation. We're looking at just the agency and partnership type of relationship where a corporation does not exist. Okay, so first things first, we're going to look at different types of business organizations. So there are several parties that are involved in a business enterprise. The first being an investor, and that is the party that usually is going to provide only financial resources. There has to be a distinction here between putting in actual labor operation into the business versus just putting up some kind of capital investment. And you'll find out later why, dealing with legality issues and who in the business can be held responsible for the actions of those involved in the business. So the investor typically is only going to actually provide financial resources. The owner of the business is the party or parties, different people, who knows, who owns the actual business. The manager is the person who operates the business. The workers, these are the people who carry out all of the tasks, daily tasks that are necessary for the business to operate. And the third party, these are all parties who are not directly related to the operation of the business. They could be people that the business has contracts with, things like that. Okay, let's look at types of business entities. So first we have traditional entities. Now, there are several types of these. The first is a sole proprietorship. This is a business that is owned and operated by an individual who has full authority and responsibility for all business decisions. So the sole proprietorship is one business, one person running the show. A general partnership is an association of at least two individuals, other partnerships, corporations, or other associations for the purpose of carrying on as co-owners in a business for profit. So there's got to be that for-profit aspect. A limited partnership is a special type of partnership created by statute that has one or more general partners and one or more limited partners. A corporation is a statutory entity whose legal existence and identity are independent of the business owner's identity. And that's important when it comes to legal issues, like being sued. You usually cannot be sued in place of the corporation. There are exceptions, but obviously that's for a different lecture. Nonprofit associations, this is the last of our traditional entities. This is an entity that exists for purposes other than earning high profit. So they may be incorporated or unincorporated, but they don't exist for the purpose of earning profits. Okay, next we have our new business entities. So the first is limited liability companies, and these are called LLCs. This combines the tax treatment of a partnership with the limited liability of a corporation. Generally, an LLC has at least 2 members, and this can be individuals, trusts, estates, other partnerships, other LLCs, or even other associations. And these members have contributed capital and have filed articles of organization with the state. The next type of new business entity is a registered limited liability partnership. That's RLLP. This is a conventional general partnership that has met certain guidelines and registered with the state. The RLLP enjoys partnership taxation and limits the liability of the partners to only their capital investment in the partnership. And finally, the registered limited liability limited partnerships. So this is the RLLLP. This is another conventional limited partnership that has met certain guidelines and has also registered with the state. The RLLLP enjoys partnership taxation and limits the liability of the general partners to their capital investment in the partnership. Okay, and finally, our third item here, the unincorporated nonprofit. So we have some cases to illustrate these types of business entities. The first is Missouri versus Kansas City firefighters. And this is a case out of Missouri Court of Appeals. This is where a voluntary association is governed by principles of agency, meaning members of a voluntary association are liable for acts of its agents when it's done within the scope of authority. Liability of the members for acts of its agents when done within the scope of authority does not devolve upon a member from fact of association only. However, from a personal act or from act of an agent whose agency must be proven. So it can't just be a member of the nonprofit that's unincorporated. You have to have some kind of affirmative act working within the association using apparent authority. So a member of a voluntary association sustains no personal liability for acts of association's officers or other members unless the member participates in, authorizes, or ratifies the acts. Another case that we have on the same issue is Security First National Bank versus Cooper. This is out of the California District Court of Appeals. Here we show that the liability of members of an unincorporated association on contracts made by it varies according to the answer to the question whether the association is one organized for profit. If the association is, in fact, not for profit, then membership imposes no personal liability for the debts of the association unless the individual member has actually or constructively assented to or ratified the contract on which the liability is predicated. So if you are a member of a nonprofit organization, you will in no way become liable for the debts of that business entity. unless you yourself have ratified the contract. And finally, another case related to unincorporated nonprofit associations is Lions versus American Legion Post. This is a case out of Ohio. In the absence of an enabling statute, a voluntary association cannot be sued by its association name. It has no legal existence, and the persons composing it must be joined individually. The existence of an enabling statute does not, however, relieve the individual members of liability, because the enabling statute will not abrogate the common law liability of the members unless the statute specifically does so. So these are all just important concepts to note regarding the liability of the individual members. So if you do decide to join or become a member of a nonprofit, I think the idea is that you shouldn't have to worry that you are going to be sued for the actions of the business entity of the nonprofit itself, especially considering it's not working for profit. It's usually working for some kind of like idealistic goal. So you should be able to engage in these activities without having to worry about being sued. Most people probably wouldn't engage in these activities if that was the case. Okay, next we have formation of a business. So we've got common law entities and statutory entities. Common law entities are entities that exist without an enabling statute. So first we have sole proprietorships. These are essentially proprietorships that have no requirements to form, and so they can operate a business without any requirements for forming or filing or anything like that. General partnerships are governed by the Uniform Partnership Act and or the Revised Uniform Partnership Act. So the Uniform Partnership Act actually defines a partnership as the association of two or more persons to carry on as co-owners or business for profit. The Uniform Partnership Act itself actually does provide governance for business partnerships in several United States. So it offers regulations regarding the dissolution of partnership when a partner dissociates as well. It's kind of like a guidance that's given to the nation by people who really know what they're talking about in the field. And so it attempts to be uniform, and then once revised as the RUPA, or the Revised Uniform Partnership Act, but it attempts to give some kind of uniformity to the states so that while we don't all have the same laws, we can kind of operate in similar ways so that when people are moving from state to state or conducting business in different states, they can kind of have a comfort in knowing that things aren't going to change too much if they try to do business in one state over another. Okay, Uniform Partnership Act Section 7 states that the receipt by a person of a share of the profits of a business is prima facie evidence that he is a partner in that business. So if you receive profits, that right there on its face, prima facie, means that you are a partner in that business. Why else would you be receiving profits if you're not a third party? No such interference, however, shall be drawn if such profits were received in payment for 1, as a debt by installments or otherwise, 2, as wages of an employee or rent to a landlord, 3, as an annuity to a widow or representative of a deceased partner, 4, as interest on a loan, 5, as the consideration for the sale of the goodwill of a business or other property by installments or otherwise. So those are all some examples of when it wouldn't be, when the receipt of profits from a business would not make that person in receipt of that money a partner in the business. But otherwise, if you're receiving profits, then it's prima facie evidence of you being a partner. So in the case In re Dalton Lodge Trust out of North Dakota, the most essential feature of a partnership is that it is formed to carry on business purposes. Other factors that are material include 1, the manner in which parties have dealt with each other, 2, the mode in which each partner has, with knowledge of the others, dealt with persons in partnership capacity, 3, whether the parties have filed a certificate setting forth the entity's assured name, 4, whether the parties have carried telephone listings, signs on premises, truck, etc. in the first name. So those are all just kind of examples of things that would show the business name somewhere. And 5, whether the parties have shared a profit. So in another case regarding the Uniform Partnership Act on profits, Stewart versus Overland Medical Center out of Missouri Court of Appeals states that a partnership is a contract of 2 or more competent persons to take their money, effects, labor and skill, or some or all of them in lawful commerce or business, and to divide the profits and bear the loss in certain proportions. The primary consideration is determining, when you are determining the existence of a partnership, the primary consideration is whether the parties intended to carry on as owners in a business for profit. So did the parties intend to carry on as co-owners? Well, one thing you can look at to determine if that's the case is, are they sharing profits? That looks like intention. Courts have said that is prima facie evidence. Okay, now looking at the revised Uniform Partnership Act, Section 1014, partnership means an association of 2 or more persons to carry on as co-owners a business for profit formed under Section 202, predecessor law or comparable law of another jurisdiction. The revised Uniform Partnership Act, Section 1018, states that person means an individual, a corporation, business trust, estate, trust, partnership, association, joint venture, government subdivision, agency, or instrumentality, or any other legal or commercial entity. So there are a lot of different things that could mean individual or person. It's not just an individual. It's also different types of business entities that could fall within that. Okay, here is a case that looks at the issue of who is actually a person within the meaning of a partner. This is a case called John versus Lamb from the Eastern District of Tennessee. A person may be a partner, though he believes that he isn't. It is the legal effect of the parties' agreement, not their subjective intent, that determines whether they are partners. And that's a big caveat. Just because you don't think that you are a partner doesn't mean that you're not one. So it's more the objective viewpoint on whether you are a partner. The Revised Uniform Partnership Act, Section 202A and B, states, unless formed under a statute other than this act, a predecessor statute, or a comparable statute of another jurisdiction, the association of two or more persons to carry on as co-owners a business for profit forms a partnership, whether or not the persons intend to form a partnership. So carrying on as one does in a business with someone else, even if you are not intending to form a partnership, you are still forming one. The Revised Uniform Partnership Act, Section 202C states, a person who receives a share of the profits of a business is presumed, prima facie on its face, to be a partner in the business, unless the profits were received in payment for one. Now, this is kind of mirroring the Uniform Partnership Act, the last part of that section that we looked at. So one, a debt by installment or otherwise, so that's the same. Two, for services as an independent contractor. Three, of rent. Four, of an annuity or other retirement or health benefit to a beneficiary, representative, or designee of a deceased or retired partner. Five, of interest or other charge on a loan, even if the amount of payment varies with the profits of the business, including a direct or indirect present or future ownership of the collateral or right to income, proceeds, or income increased in value that came from that collateral. And finally, for the sale of goodwill of a business or other property by installments or otherwise. So basically some cases came about after the original Uniform Code, and we were faced with some situations where we kind of had to add that in. Here's another case dealing with these specific codes here to kind of shed some light on it. Fenwick versus Unemployment Compensation Commission of New Jersey. So here the intention of the parties to form a partnership was only one factor. There were other factors to consider when determining if a partnership exists. So other factors in that situation include the right to share in profits, one. Two, the obligation to share in the losses. Three, the ownership and control of the partnership in property and in business. Four, the community of power in administration. Five, the conduct of the parties toward third parties. And six, the rights of the parties on dissolution. So what's happening once we're actually sitting down and saying, you know what, we want to dissolve this partnership? What are the rights of each individual at that point? Okay, now let's take a look at under common law, still our last type, we have joint ventures. So a joint venture is a common law business entity that closely resembles a general partnership and is treated very similarly to a general partnership. So a case for this is Crest Construction Company versus Insurance Company of North America. A partnership is an association of two or more persons to carry on as co-workers a business for profit. A joint adventure is a special combination of two or more persons, whether corporate, individual, or otherwise, which seeks a joint profit in a specific venture. Partnerships and joint ventures are separate legal relationships, although they are generally governed by the same rules of law. So a joint venture is two or more people engaging in business in only one specific venture. You're not one business entity that's handling all aspects of business in different areas of business. And now, the concept is more to keep people still responsible for their actions. So by forming a joint venture, you're not going to get out of any kind of liability in that with respect to that venture itself. Instead, you're still going to be held under the same laws as you would if you were in a partnership, a general partnership. Okay, now we're going to go ahead and look at statutory entities. So for these, we have limited partnerships. Well, first of all, statutory entities are entities that require compliance with formal statutory requirements. So here we have limited partnerships. Now, limited partnerships were known at common law, or excuse me, they were unknown at common law, and they are exclusively a creature of statute. So their main purpose is to permit a form of business enterprise other than a corporation in which persons could invest money without becoming liable as general partners for all debts of the partnership. The general purpose was to enable persons to invest their money in partnerships and share in the profits without being liable for more than the amount of the money that they actually contributed. So under the Uniform Limited Partnership Act, Section 1017, a limited partnership means a partnership formed by two or more persons under the laws of the state and having one or more general partners and one or more limited partners. Section 102 states, the name of the limited partnership shall contain the words limited partnership. The names may not contain the name of the limited partnership unless it is also the name of a general partner or the business of the limited partnership had been carried on under that name before the admission of that limited partner. Section 208 states, the fact that a certificate of limited partnership is on file is notice that the partnership is a limited partnership and that the persons designated as a general partner are general partners. So then filing that paperwork, the certificate, is enough to put people on notice of who they are and what their roles are in the business. This case, Dwinell Central Neon versus Cosmopolitan Chinook Hotel, out of the Washington Court of Appeals. A third party's knowledge regarding the status of a limited partnership is irrelevant when at the time of contracting, the partners have made no attempt to comply with the statutory information and filing requirements of the Limited Partnership Act. Since limited partnerships were unknown at common law, A party seeking the protection of limited liability must have substantially complied with the statutory requirements. So you have to comply with the statutory requirements, because otherwise third parties are not going to have knowledge of you. And this court's saying that it's irrelevant. It doesn't matter. You can't hide behind your lack of filing to avoid liability from a third party. Okay, moving forward, we have contractual liability of business enterprises. So in this section, we're going to be talking about the roles of people and how they can become liable or create liability on the behalf of the business. So an employee or independent contractor can only bind an employer to a contract with a third party if two requirements are satisfied. The first being, the employee or independent contractor is in an agency relationship with the employer, in which the employee or independent contractor is an agent of the employer. And two, the agent had authority to enter the contract on behalf of the employer. The authority may be one, actual authority, or two, apparent authority, or three, inherent authority arising from the agency relationship. The principal may also be bound to the third party on account of a transaction with an agent because of the principles of estoppel or unjust enrichment. So that's a lot of information that we're going to go ahead and get through right now, but it just shows that someone who is acting as an agent on behalf of a business entity, someone who has actual, apparent, or inherent authority can in fact bind the business into a contract with a third party. So looking at general and special agents. A general agent is an agent that is authorized to conduct a series of transactions involving a continuity of service. So someone who is an integral part of a business organization and does not require fresh authorization for each transaction is a general agent. So for example, the president of a company, they don't have to keep coming back to the board to say, hey, can I get agency please to go and talk to this third party? No, they automatically have agency on behalf of the company. A special agent is an agent authorized to conduct a single transaction or a series of transactions not involving continuity of service. So this is someone who isn't actually probably one of the officers. It's someone who has been brought in just for a specific task. Now looking at the agency requirements. Agency is a fiduciary relationship. The relationship is created when one person, the principal, manifests an intention that another, the agent, shall act on its behalf, and the other person, the agent, consents to represent him or her, the principal. There is no requirement for consideration because the relationship created is not necessarily contractual in nature. Thus, the relationship may be created expressly, either orally or in writing, or implied by some other conduct by the principal that may be interpreted as an objective intention to appoint an agent. Here, a rule of law from the Restatement of Agency states that an agency relation exists only if there has been a manifestation by the principal to the agent that the agent may act on his or her own account and consent by the agent so to act. So the principal has to actually show the agent that they have to manifest their desire for that person, the agent, to be the agent. The agent has to realize that that's the case, and they have to consent to being the agent. Okay, now looking at the authority requirement. So actual authority is created by written or spoken words. So for example, it's called express authority, or expressly giving you authority, or other conduct by the principal. So, and that would be implied authority, other conduct other than like expressly writing out or saying something, which reasonably interpreted by the agent causes the agent to believe that the principal desires him or her to act on the principal's behalf. So here, express authority includes authority that's granted by words, which expressly and directly authorize the agent to engage in certain conduct on behalf of the principal. Implied authority is authority implied from the surrounding facts and circumstances. Incidental authority is actual authority that includes when an agent reasonably presumes that he or she possesses by virtue of the position she occupies or the responsibilities that she is in charge of. So this can include authority to do ministerial acts and other acts that are necessary for the agent to carry out his or her duties as an agent. So here's a case that helps to illustrate this. Epstein versus Corporación Peruana de Vapores, Southern District of New York. Implied authority is authority that comes in conformity either with law or the general business customs of a particular trade. Where conformity with law is concerned, the captain of a vessel has implied authority under admiralty law to bind the owner thereof that he purchase necessaries for the use of his ship, not for the use of other ships in the fleet. Here's another case. Penthouse International Limited versus Priscilla Barnes. Implied actual authority requires that the reasonable belief of the agent that he was authorized to modify the contract based on the principal's conduct known to him. Another case that we have is Federal Land Bank of Omaha versus Sullivan's. An attorney who is clothed with no authority other than that arising from his employment has no implied power to compromise or settle his client's claim. A principal, however, will be liable for contracts made in its behalf by an agent if the agent was authorized to enter into the agreement. The authorization may be either actual or apparent. Actual authority is created by manifestations from the principal to the agent to believe the agent has the authority to act on the principal's behalf. This actual authority can also be created by the acquiescence of the principal in the actions of the agent. Apparent authority, on the other side, is created by manifestations from the principal to a third person to believe the agent has authority to act on the principal's behalf. So a big concept here is that the agent has to know and believe that they have the right. The third party has to know and believe that the agent has the authority. We really don't want a third party to end up getting injured in a contract because they believe they were actually entering into a contract with a business when in fact the person they were speaking with had no authority to act on behalf of the business. Apparent authority. This is created by written or spoken words or any other conduct of the principal, which, reasonably interpreted by a third party, causes the third party to believe that the principal consents to have the act done on his or her behalf by the person purporting to act for him. So a case here is Zumek versus Polasek out of Wisconsin. Power to bind the principal may result from consent of the principal manifested to third persons by formal or informal writings or by spoken words, or it may result from manifestations of consent on the part of the principal implied from authority to do other acts. This is called apparent authority. So basically, it can arise out of written or spoken acts or other conduct that's going to make the third party reasonably believe that that person is an agent of the business. Okay, let's look at the concept of estoppel as it relates to apparent authority. Apparent authority arises when an employer's actions lead a third party to reasonably believe an agent has authority. In contract law, estoppel requires the same elements as apparent authority, plus the third party must also change his position to his detriment in reliance upon the employer's action for estoppel to apply. So here's a case illustrating that concept. Walker versus Pacific Mobile Homes out of the state of Washington. Authority to perform services for a principal carries with it the implied authority to perform the usual and necessary acts essential to carry out the authorized services. One dealing in good faith with an agent who appears to be acting within the scope of his authority is not bound by undisclosed limitations on the agent's power. So the assumption is that if you're there to do the job as the agent of the business, that you are going to be doing the job the way that it's supposed to be done, basically. There should be no undisclosed limitations that the third party is unaware of. We're really protecting the third party in this sense because, you know, it can be easy for someone to act as an agent, but then claim later that they were not one in order to get out of a contract with a third party. Okay, let's look at inherent authority. This is authority that is created solely from the existence of an agency relationship. The source of the authority is the status or position of the agent in the business enterprise on whose behalf she is acting. Inherent authority exists independent of either actual or apparent authority because it would be unfair for an enterprise to have the benefit of the work of its agents without making it responsible to some extent for their excesses and failures to act carefully. So here's a case that looks at the inherent authority of partners. Insofar as the partner limits his conduct to matters apparently within the partnership business, he can bind the other partners without obtaining their written consent. There must, however, be express authority for acts of a partner which do not appear to be within the usual course of the business. Another case involving this states that a partner has both actual and apparent authority to act within the usual course of partnership within the business, even though the authority is used illegally. Now, in acts of an unauthorized agent, here, an agent pursuant to her authority who obligates her principal to a contract is not bound to the contract, even though the principal is. However, if the agent acts outside the scope of her authority, for example, actual or apparent authority, the principal is not bound by the contract, but the agent is. So the corporation would not be bound, but the officer, for example, the president of the company, would be. The principal may, however, become bound by the unauthorized acts of the agent. One, if she knows about the unauthorized actions of the agent but does not object. Two, if she ratifies the acts of the agent. Or three, if she receives the benefit of the unauthorized actions. Okay, so let's look at termination of authority. So there can be, we need mutual consent. The authority of an agent terminates in accordance with the terms of an agreement between the principal and the agent with just mutual consent, both agree. Revocation or renunciation. Authority terminates if the principal or the agent manifests to the other dissent to its continuance. The death of the principal. The death of the agent. The loss of capacity of the principal or the agent. And here's a case that illustrates this. So in Gallup versus Barton out of Massachusetts, the death of the principal terminates the authority of the agent with or without notice of the principal's demise. So regardless, the agent's gone, the agent has passed on, it's terminated. The agency relationship is terminated. Here is an exception to the rule. So there is a type of agency that is considered irrevocable. And an irrevocable agency, which is also called an agency coupled with an interest, so a power coupled with an interest or a power given as a security, is generally irrevocable under any circumstances. So a power given as security is a power to affect the legal relations of another, created in the form of an agency authority, but held for the benefit of the power holder or a third person, and given to secure the performance of a duty or the protection of a title, either legal or equitable, such power being given when the duty or title is created for consideration. Here's a case to illustrate. A power is said to be coupled with an interest when the power forms part of a contract and is a security for money or for the performance of any act which is deemed valuable and is generally made irrevocable in terms, or if not so, is deemed irrevocable in law. To be deemed irrevocable in law, the power must coexist with an interest in the thing or estate to be disposed of or managed under the power. So if there is some kind of outside interest that's being gained by the agent, then, like, for example, they're getting royalties off of a deal or something like that, then it's going to be irrevocable. It's not going to end or terminate after, for example, the death of the principal or the death of the agent. All right, let's move on. Fiduciary obligations of parties associated with business enterprises. The fiduciary must be loyal to and most unselfishly serve the interests of the person or enterprise the fiduciary is acting for or on behalf of. Fiduciary law imposes a high standard of morality upon a fiduciary and describes the fiduciary's duty in terms of loyalty, fidelity, faith, or honor. The fiduciary is obligated to place the interests of the person or enterprise on whose behalf he is acting above his own interests. So what is a fiduciary? A fiduciary relationship is one founded upon trust or confidence reposed by one person in the integrity and fidelity of another. A fiduciary is held to something stricter than the morals of the market. The fiduciary relationship is the punctilio of honor and the most sensitive. So they take it very seriously. If you're a fiduciary, you're acting and you have to act with the most high level of loyalty and honor. Statutory fiduciary obligations. So we've got general partnerships where every partner has to account to the partnership for any benefit and hold as trustee for it any profits derived by him without the consent of the other partners from any transaction connected with the formation, conduct, or liquidation of the partnership, or form any use by him of its property. So basically, the only fiduciary duties a partner owes to the partnership and the other partners are the duty of loyalty and the duty of care. The duty of loyalty is 1, to account to the partnership and hold as trustee for it any property, profit, or benefit derived by the partner in the conduct and winding up of the partnership business, or derived from a use by the partner of partnership property, including the appropriation of a partnership opportunity. 2, to refrain from dealing with the partnership in the conduct of winding up the partnership, or on behalf of a party having an interest adverse to the partnership. And 3, refrain from competing with the partnership in the conduct of the partnership. So essentially, we can't have conflicts of interest. You have to be loyal just to the partnership. So don't compete with the partnership. Hold them in high regard. Use conduct that is not adverse to the interest of the business itself. That's your duty of loyalty. Duty of care, a partner's duty of care to the partnership and the partners in the conduct and winding up of the partnership business is limited to refraining from engaging in grossly negligent or reckless conduct, intentional misconduct, or a knowing violation of law. So treat the obligation to your business with care. Refrain from engaging in grossly negligent or reckless conduct, intentional misconduct, or knowingly violating the law. Okay, covenants not to compete. So employee covenants not to compete, which are also called negative covenants or post-employment restraints, are contractual agreements that restrict an individual from competing with a former employer after termination of his or her employment. It's generally stated that a covenant not to compete cannot stand on its own, but it has to be ancillary to a valid contract or employment relationship. A covenant not to compete has to satisfy the following initial criteria before it can actually be enforced. So 1, the covenant is ancillary to any otherwise valid transaction or relationship. 2, The covenant is supported by adequate consideration. And 3, there is a legitimate employer interest that the provision is designed to protect. So there has to be a reason for it. We can't just have a covenant for no reason. We can't just tell people that they're not allowed to go out and engage in business when it's not really anything that should be protected in the first place. Okay, so covenants not to compete when we're looking at the sale of a business. When a business enterprise is sold, it is typical for the seller as part of the transaction to agree not to compete with the business after the sale. So basically, if you're Best Buy and you're selling to Circuit City, which is like kind of the opposite of what happened, you are, ideally Circuit City would contract with you a covenant not to compete, that you're not just going to go pop up another Best Buy like store to compete with the new business. Covenants associated with the sale of a business are subject to the same rules as employee covenants not to compete. Consequently, a court will usually enforce a business seller's covenant not to compete when a business is sold as a going concern that the goodwill will also go along with them. Okay, so termination of employees. So traditionally, an employee who works without an employment contract is called an at-will employee, and they can be fired with or without cause, without any recourse against the employer. Good cause, meaning a reasonable job-related ground for dismissal based on a failure to satisfactorily perform job duties, disruption of the employer's operation, or other legitimate business reasons. So looking at the at-will doctrine, public policy, in general, it can be said that public policy concerns what is right and just and what affects the citizens in the state collectively, such as matters affecting a citizen's social rights, duties, and responsibilities. So for example, this case, Peterman versus International Brotherhood of Teamsters, so Teamsters Union, it's out of California. An employee stated a cause of action for wrongful discharge when he claimed he was fired for supplying information to police investigating a coworker's alleged criminal violations. In another case, Allen versus Safeway stores out of Wyoming, to contend that an employee can talk in a derogatory fashion to customers or business contacts of his employer and be protected from disciplinary action by the employer by virtue of the right to speak freely is obviously an error. So that would be good cause to fire someone. And finally, liquidating a business, wrapping it up. So we have several different phases here. First is the dissolution stage. This is a voluntary decision, an occurrence of certain specific events, or a judicial decree that results in the business enterprise ending its ongoing operations. So when this occurs, the business is then dissolved. The winding up stage. The business continues to exist, but it has entered the winding up stage of liquidation. Usually this involves converting the assets to cash, which to pay off creditors, and any remainder being distributed among the business owners. So the cash will be used to pay off any remaining liabilities. The termination stage. The final stage occurs at the conclusion of the winding up of the business affairs. At this point, the business actually ceases to exist. So looking at liquidating the business enterprise, with a sole proprietorship, this can be dissolved, just like it is created without any actual formalities. The owner of the sole proprietorship is free to dissolve the business at will for any reason or for no reason. With the corporations are legal entities that exist separately from their directors. So consequently, they cannot act on their own, so appropriate formalities must be complied with for the corporation to end its ongoing operations. And that is going to wrap up our lecture on agency and partnership. I hope you enjoyed yourself. Have a wonderful day.